Well, good morning, everybody. Welcome back. It's been a while since we've had anything to talk about in the state of Bryan, case of State versus Bryan Kohberger. Last hearing we had was the evidentiary hearing on the defense motion to compel, where we heard that testimony from the defense expert Cy Ray about problems with the location analysis that the Moscow police performed to try to locate Bryan Kohberger, try to locate the offender, and try to tie those two things together. And we haven't yet gotten a ruling on that motion. So nothing really substantively new to report since then, but we do have this hearing today to look forward to maybe getting a little bit of a preview of what the defense is thinking and what some of their strategies are going to be moving forward in this case. So if you've been following this for any significant length of time, you know the defense is going all in on Bryan Kohberger is innocent. He is not the person who committed this crime. And they have given us their explanation for why it is that they think that way in little drips and drabs throughout the court pleadings. So, for example, statements that contrary to expectations that Bryan Kohberger's car, once he was arrested, was going to be a moving crime scene. It would be full of evidence, given he is supposed to have driven this car away from the scene moments after having committed these very brutal murders. Despite that, police apparently did not locate any victim DNA in the car, any victim DNA in his apartment, and have produced no evidence of any connection whatsoever with any of the victims in the case. Subsequently, through these later hearings, these more recent hearings that we have gotten that relate to discovery disputes in the case, information that the defense is trying to obtain to understand how police reached their conclusion that stated in the probable cause affidavits that basically Mr. Kohberger's whereabouts were able to be traced at certain points over the course of that night and then the following morning. The information that we have from the defense expert Cy Ray is that everything he has seen so far is exculpatory to Mr. Kohberger. And because there is a substantial amount of information, important information that the state has not yet turned over, he can't make a final determination on that. It is possible that some of what is being withheld would change his opinion there. But based on what he has already seen, his view is that that evidence is exculpatory. So these have been quite a bit of a bombshell if you've been following closely in the case, because of course, if you just see the public narrative, what's been reported in the media, the mainstream sources, and now there's another book out there. We'll talk about that briefly. But if that's the only thing that you've heard about this case, you've probably considered it just wrapped up, slam dunk case that Bryan Kohberger did it. He's clearly guilty. And it's only if you're really following these proceedings a little bit more closely that you might be getting the impression that actually that may not be the case. It is not looking nearly so clear as perhaps in the very early days following this arrest, people really wanted it to be. So for today's hearing, it's not going to be sexy, guys. Not expecting any big drama here, not expecting witnesses to testify. This is just a scheduling hearing. But the reason why I think this is going to be interesting is because of the nature of what it is they're going to be scheduling. So first off, I mean, just a trial date alone. We've been waiting for a trial date in this case for months now. Uh, it was, I think, back early this spring where the state had originally requested. They had wanted a trial date this year. The defense is clear that they're not going to be ready within that time frame. There's obviously still discovery that's outstanding that we've just gotten through the process of litigating. There was a whole pause in the process because the defense is anticipating moving to change the venue out of Latah County and had been conducting surveys, professional surveys done in accordance with professional standards to evaluate the potential for bias in the jury pool. The state had found out about that, got quite upset about it, got an emergency order staying their ability to complete those surveys until a court hearing could be held. So that took some time. The court hearing was held. The court did determine, after hearing from everybody involved, the defense survey expert, that there's nothing problematic here. This is normal, customary, the types of things that you have to do to be able to make this type of showing that's required to meet the standard for a change of venue. So that put quite a bit of a hold on things because, if you can't complete your survey, you can't get your basis for evaluating the need for that motion. And of course, you can't file the motion, which had been set at that point in time and has now been stricken. So there are a number of things that we are waiting for in addition to the trial date, which is on the docket for today. So among the things that the court has indicated in this order, the order basically just says counsel shall be prepared to address scheduling dates, including a briefing schedule and oral argument dates for pretrial motions, including motions to suppress, which the defense has highlighted. They have signaled very strongly they are going to bring motions, motions in the plural, not just one motion on one ground, no, multiple grounds that they think they're going to be able to show, to establish that evidence was improperly obtained in this case. Because of that, the prosecution should not be allowed to use that against Mr. Kohberger. Motions in limine concerning the mode and manner of presentation of evidence at trial, the trial conduct in general. Those usually happen pretty close to the trial date. And any motions challenging the death penalty. This came up at the last hearing where the defense signaled that potentially as a discovery sanction, they would be making this request to take the death penalty off the table. You may remember, if you were paying any attention to the prosecution of Lori Vallow, also here in Idaho, the trial took place down in Ada County in Boise. The death penalty had originally been sought in that case, and it was stricken there due to a discovery violation. Basically, a determination made by the trial court that because of the failure to turn over certain materials, that was an appropriate remedy for that failure. So a little bit of a signal here from the defense that potentially that might be on the table too. And the basis for that may in part be because some of the information that Moscow Police Department relied on to do a lot of this location analysis and other parts of their investigation, they got from the FBI. The FBI was a partner investigator in this process, which is not uncommon at all in small rural communities that have very limited resources of their own. They will pull on the resources of other law enforcement agencies at the state and the federal level who are willing to step in and assist them. So the FBI had taken on that kind of support role in this case, but now is not apparently inclined to share a lot of its material, a lot of what it relied on with the state or with the defense. That's been the subject of some of this discovery litigation. They're having to go through the TUI process, which if you followed Karen Reed, you're familiar with the TUI process and why it was kind of extraordinary in that case that the feds, in an open investigation, just went ahead and handed over thousands of pages of work that they'd done, grand jury materials, just evidence that they'd obtained. Pretty remarkable for something like that to happen. Because TUI basically protects the federal government's files. They don't have to turn anything over to the state. They're a separate sovereign. You don't really have any recourse if they decide they don't want to give you their materials, but they have the specific procedure that they go through and regulations they have to follow for sharing of information. Well, apparently they have not been so inclined to share that even with the state. The state has indicated, look, we don't have it, we can't get it. They're kind of being forced to go through the TUI process with the feds, which is quite unusual. The state typically does not have to do this. It's a process that's really there to keep the defense from being able to go on a fishing investigation in the feds' files. So problems with those kinds of foundational materials that would prevent the defense from being able to evaluate fully how did the police even reach this conclusion that it was Mr. Kohberger, that his locations can be correlated with the movements of the white car that they claim to have identified and seen on video. So motions challenging the death penalty, that is likely what that's about, a sanction for potential discovery non-disclosure. Also, expert disclosure deadlines, a trial setting, and deadlines for filing pretrial materials such as proposed jury instructions, juror questionnaires, witness lists, and exhibit lists, and sentence disclosure deadlines. So we've seen from Judge really throughout the whole process of this case, he really he likes to keep things organized. He likes to keep things tidy. He will break away from the subject of emotion to address, things that have been filed that are outstanding. It's like he's kind of got a running list of loose ends. He doesn't like loose ends. So this order seems to really reflect that he wants to make sure there are really no surprises going into the trial process, that it's orderly, it's done in a fashion that is going to be fair for everybody to have time to do what they need to do and also respond as they're allowed to do, to have the proper notice of what's to be expected. So this is really consistent with that. The million-dollar question, I think, today is really when's the trial date? When is the trial date going to be? It's a little bit, I have to notice in that list, we did not hear motion for change of venue. The defense has been pretty adamant up to this point that they don't feel that Mr. Kohberger can get a fair trial in Latah County, that the preliminary information they had gotten from their surveys suggested that that was not going to be feasible. They had presented some statistics about the prejudgment and things like that were a little bit problematic. But what they hadn't been able to complete up to that point in time was comparative surveys in other counties. If Latah County is no more biased than everywhere else, then it's not necessarily doing you any good to move it. So that we don't know. That piece of information is not part of the public record at this point in time. But it is curious. I just noticed that omission, that motion for change of venue, not here on this list of things to be scheduled. And that does, it raises the question to my mind if the defense is going to proceed with that, because typically if you're going to set a trial date, you need to know where you're going to set it. You need to know the schedule of the court where it's going to be set in. So if it's going to be in Latah County, that's pretty easy for these folks to determine. They can look at Judge's schedule. They can look at the docket for Latah County going forward into the future. And that's not difficult to do. But if this trial is going to be moved into another jurisdiction, well, now you have a whole process of having to coordinate that with the court that you're moving it into. So I don't know if we're going to hear anything about that today. I do wonder, but it's an omission that I noticed. Just made me question, is that a deliberate thing? Is there something that they don't know about? Perhaps that motion is not going to go forward, or was it just inadvertent? It's kind of fallen to the back burner in light of all of these other issues that have recently been raised. And this is maybe perhaps an incentive to just kind of keep the ball rolling. We have been waiting for a trial date for some time. The state had originally, like I said, wanted it to be this summer. That's not going to be on the table. It's just not realistic. I don't think their existing discovery cutoff is even before later this year. So it's likely to be sometime next year. The question is exactly when. The state has kind of been inconsistent a little bit in terms of when they want it. They wanted March, they wanted the summer, because the summer would be when the school is out. And given that Moscow is a small town and there's just, it's going to be disruptive to have this trial going on, the witnesses coming in and out, the press in town, the just busyness at the courthouse. It's gonna just complicate things. And so it's kind of easier in the summer if school is not in session, and then, people aren't gonna have to fight over parking and stuff like that. It seems like a trivial thing, I think, to a lot of people, but to the people in the small town, it very much isn't. I do have some sympathy for this this preference, that it just be as little disruptive as possible to try to minimize that. It's different in a place like Manhattan or Los Angeles or a large jurisdiction where you have such a big population anyway. You're used to managing large numbers of people. That's not what we have here. It's just not the same community. The defense has suggested that the summer of next year is about as early as they would be prepared to go, and it wouldn't surprise me at all if they would, prefer for it to be longer. Just given the massive volume of information, the possibility that things continue to trickle in, that they have to be able to address, a large number of experts to be able to deal with, and so forth. So at the same time, of course, Mr. Kohberger is still sitting in jail. He has been sitting in jail since he was arrested in December 2022. Over a year, almost 18 months. And of course, nobody wants to be sitting in jail longer than you have to. He is undoubtedly eager to get this done and resolved one way or another. It isn't just obviously the loss of freedom is not awesome. Nobody is going to like that. But there is a limbo state that you're in this type of process. You guys who are waiting for the Karen Read verdict, you understand the psychological pressure that this limbo state can really put you under. Just the uncertainty of not knowing what the situation is, not knowing what's going to happen, not knowing what to expect. You're on pins and needles because you're just not at the end of the road yet. And that very much happens with the criminal case as well. It can be just extremely difficult to have to wait. And if we credit the defense assertions that Bryan Kohberger is in fact innocent, it's going to be very frustrating for him to be sitting in that little jail cell, doing the little jail things, knowing he shouldn't be there, and having to wait and wait and wait and wait and wait some more in order to be able to finally get his day in court, where he expects and has expected from day one, from his own statements to his public defender there in Pennsylvania, that he is going to be exonerated. So, all right, guys, looks like we have the court now. Don't see that the sound is on. The judge is not yet on the bench, but we should be getting something pretty
All right.
soon.
Thank you very much. Please be seated. Morning, everybody. Okay, let's get on the record, please. Thank you. We are now on the record. This is State versus Bryan Kohberger, CR 2922-2805. Present in the courtroom is Mr. Kohberger, represented by Ms. Taylor, and Ms. Massett and Mr. Logston are participating over Zoom remotely. The state is represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office, and Mr. Nye and Ms. Beatty are participating over Zoom remotely. So we're here for a scheduling order, and I think we're about 13 months from the arraignment, and I think at this point, this is my opinion, that we're getting to a point of diminishing returns, and I sent to council last Friday on a proposed scheduling order for a lot of things, deadlines, including setting the trial. And so I also have set this hearing so that we can discuss this and see kind of where everybody is. So let me start with the state. Thanks.
Thank you, Your Honor. We've reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street and when the university is out in conflicting activities. And the schedule that Your Honor proposes is acceptable to the state. I would note just a minor detail that June 19th is also a legal holiday. The court specified July 4th as a legal holiday. We wouldn't be able to hold trial, but
Sure.
19th as well. Other than that, we have no objection to the court's proposal.
All right, thank you. I mean, as I went through all of this, I mean, there's going to be a lot of motions, a lot of hearings, a lot of work. There already has been a significant amount of work, as we all know. And when I tried to balance this out, I do think it's pretty fair, balanced, and I hope realistic. So, Ms. Taylor.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's to come.
Totally understand that.
So I don't want anybody thinking I'm agreeing to Latah County as all. The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So I was calculating 2 weeks to set the jury, then 8 weeks of trial, and then 2 weeks for mitigation sentencing. And I mean, that's a guess, but I think it's enough time for all of those things to take care of. And obviously, the last 2 weeks would only be if Mr. Kohberger was convicted. Okay, go ahead.
Thank you, Your Honor. I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Kohberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to the court for the court's consideration. As far as motions challenging the death penalty, and that's in right under motion practice letter A that the court has on its draft, we can have a lot of those filed by September 5th. I would note for the court that that's ahead of the state's final discovery date, and that's ahead of the state's deadline to produce its aggravation case that it will use. We can meet this September 5th deadline, but we're going to ask the court to give us a little leeway when there's something new that comes our way. If there's an amendment to a motion or a new motion that becomes relevant based on something new, we'd like a 2-week window after receiving something new to file that. But the bulk of it we can get in by the deadline that the court has asked here, and that's just not a problem.
Sure, I understand that. I mean, I looked at that. I wanted to have that early because, you know, it's a bigger question.
Yeah.
And I was aware of the Ross case. I think you had 16 motions in that case. So, I wanted to sort of address those issues early.
Your Honor, we can definitely do that. We can address a lot of things early. We just don't want to be precluded from bringing an amended motion or a new motion if something new is filed that would have been relevant to something we've already filed.
I'm not going to prevent you from doing that.
Perfect, thank you.
And by the way, a lot of these deadlines, I mean, you can certainly do them earlier if you'd like to. I would encourage everybody to do that. Thank you.
Your Honor, then moving on, the motions in limine under letter C, the court has suggested February 13th as the date for that. I think in large part we can do some by then, but the exhibits that we'll exchange and witness lists that we'll exchange aren't due until after that. And again, I think there might be additional motions that would be relevant after those things have been exchanged. So if the court wanted to move the whole deadline so we had all of those motions in limine at once, I think that would be reasonable. But if the court wants to keep this deadline, as long as we have the ability to bring more motions in limine based on new filings, we'll be okay with that as well.
Sure. And I was also thinking about, you know, I guess experts, for example, I mean, they may have longer hearings that, you know, we're going to have to work through all of these things. I mean, this is just a structure.
Thank you. The court had listed March 14th as a trial brief date, and that is ahead of some of the other deadlines, recognizing that the trial is the innocence phase and the sentencing phase, if it happens, is the mitigation and aggravation. I would just say this is a fine deadline, but we won't be touching anything to do with our mitigation by then, if that's what the court anticipated.
Yes.
Okay, perfect.
I think we, well, yeah, we had March 3rd for mitigation. I figured by then you would pretty much have that in hand.
We hope to. That brings me to the last point I wanted to talk about. The court has proposed setting a mutual exchange of aggravation and mitigation materials, and I'd ask the court to reconsider that. We will aim for our March 3rd deadline. That's our plan right now. If something changes that, then we'll come back and let the court know and talk to counsel. but would ask that the state's aggravation package be provided to us earlier than the same day as our mitigation. Should we get to that point, the state has the burden of establishing the statutory aggravators. There are some things I think I might be able to guess about how the state's going to try to present information, but I don't think I should have to guess. I think I should have that information well ahead of providing the mitigation that will be presented in response to any aggravating information that's presented by the state. So I'd ask the court to set the date for the state to produce its information much earlier than ours. The state filed its notice a year ago yesterday, and I have a lot of questions about what the state would intend to use to try to establish many of the statutory aggravators they've listed. I know I've heard the court talk about super due process in a capital case, and I think it's appropriate for us to be on notice and be provided discovery, to be provided a full range of what the state intends to use to establish those if we ever get to that point. And I think we need those ahead of our deadline for mitigation. So I'd ask the court to move that deadline up quite a bit earlier. And that's it.
Thank you very much. Mr. Thompson, do you have any issues about having the aggravation in advance for a period of time?
No, sir. As long as we will have the option, the ability to supplement that once we see whatever the defense plans to offer in the way of mitigation.
Well, I'm appreciating that, with these deadlines, that we're going to have supplement all the way along. I just don't want to be scrambling around a month before the trial. We're all going to be very, very busy. And the more we can resolve certain motions, supplements, whatever we need to do, I'm trying to do this sooner than later.
Yes, sir. And that's our preference as well.
And Ms. Taylor as well.
Yes, Your Honor.
But just to make sure, though, you have to do your job, and the state has to do its job, and I have to do my job. But I think this is a great step, okay, to set these deadlines and hearings so that we can move through this. It's going to take a while, but anything else we need to address today, Mr. Thompson?
I don't believe so. Thank you.
Ms. Taylor?
No, Your Honor. Thank you.
Okay, well, it's very short, and I'm grateful that everybody's working together. Thank you. Okay. Take care, everybody. We are adjourned.
All right, looks like that is that. So what's going to happen more than likely here is that we will get a written order. It'll be filed. It sounds like he has circulated the proposed order with all of the deadlines for them to be able to have this discussion. Talked about some of them, but obviously not all of them. So summer of next year, we'd be looking at for trial. That's not a surprise, very much in the kind of time frame that has been under discussion for, quite a few months at this point in time. So seems like they're on track for that. Folks who are wondering, why are they talking so much about mitigation? Mitigation is absolutely critical to a death penalty case. Even if you don't expect you're going to need to use it, you have to be prepared to be able to present that information. And so mitigation is basically any information that the jury should know for purposes of considering leniency in the case. The mitigation goes to the sentencing phase. Although it doesn't only go to that, there is some case law that suggests part of the duty to mitigation, to investigate mitigation evidence, also relates to the duty to investigate, alternative resolutions, things like that, plea bargains, to convince the prosecutor basically to take the death penalty off the table. So this is just going to the effective assistance of counsel requirement. They absolutely have to do this, even if they fully expect it's not going to get to that point, that he's going to be exonerated and they're going to get an acquittal. I appreciate that clarification from Anne. The motion to change venue has not been addressed, so it is still on the table. They are still going to be contemplating that. Of course, one of the big questions that I had coming in, and now we know it is still on the table, but hasn't been worked into this overall schedule at this point in time. So that does tend to mean that these could be preliminary. This could be modified if there is a motion to change venue and that motion is granted, because they'd have to go through that process of getting it all coordinated with whatever jurisdiction they ultimately transfer it to. So a nice, quick, short hearing. Quite a bit of a change from what we've been accustomed to on the channel over the past couple months or so. Well, how do you like? I mean, I know there's people out there that aren't crazy about Judge, and I've had my issues with Judge and some of the decisions he's made, and just his kind of wants everybody to get along type of demeanor. But I have to say, after all of this time in Judge Bev's courtroom, personally, I just find it so refreshing to have somebody who listens to the defense, understands their perspective, tries to be reasonable and even-handed and fair to both sides. It's kind of like getting a nice cool drink of water on a hot summer day. This little dose of Judge that we got. So I do appreciate his demeanor in that regard, and his effort to be fair to both sides. The defense has made good points in this. Yeah, you can't cut off your ability to be able to raise arguments when the reason you would be making those arguments, that deadline hasn't come yet. So would Bev be so accommodating? Gotta wonder. But Judge clearly understands that. He's not trying to play gotcha kinds of games with the deadlines. Just really wants to be sure that everybody, is getting a fair shake here. That's what's in everybody's interest. It's what blows my mind when you have judges that are just so one-sided and not open to one of the parties, because you're just increasing the likelihood that you're going to have to do it all over again. Sometimes the defense is right. Sometimes you really should listen to them, because they could be saving you from a lot of effort to have to do all this over again. And I think Judge has made it very clear he does not want to have to do all this over again. And so just really minimizes that risk by, take the time, be fair, understand why the defense is asking for what they're asking, and just try to do something reasonable and even-handed under the circumstances. So I'll be looking forward for this order to come out. Maybe we'll go live when there's a filing that will be confirmed. It might even be soon. If they've already agreed to it, then he's just got to go off the bench and sign it. Maybe he's going to tweak it a little bit in light of these comments that were made about either pushing back dates, like the date for the motion in limine, or including some language that, things that come up after the fact can still be raised within, like Ann Taylor suggested, 2 weeks of getting new information or something like that. But that shouldn't take long, so we should get the order fairly soon. And then we'll see what we have to work with. It's going to give us kind of our own timeline too. I mean, boy, if there's going to be motions to suppress, I'm going to be here. I'm going to be watching those. If I'm not in Latah County, I might be in Latah County to watch some of these, just depending on how it looks, how things are going to unfold. So not much of a hearing for today, guys, but did give us some good information about what's coming, what to expect, and what has and has not been taken off the table. So let's go ahead and take a look at your comments here, guys. Duncan, Idaho, he looks like a murderer to me, but who knows how many biases I have in forming that impression. It's way more important that we keep the state honest. I'm just here to tell you murders can look like anything. They can really look like anybody and anything. I understand why people may have that impression, and I think some of it is because of how he was originally presented to the public. We were absolutely primed to think, oh my gosh, this is the guy, because we've been waiting for an arrest. I don't know about you guys, but I had started to lose hope that they were going to break the case. I really had. It had been like a month since the murders had happened. Not really getting any visible signs of progress in the investigation, not really getting information about what's really happening, other than just like the bolo for the white car and things like that. I had really started to lose hope that they weren't going to be able to find out who did it. In part because I think the normal expectation with a crime like this, you assume it's going to be somebody close to them, somebody who knows them. It usually is. It's not a random stranger with no obvious connection. And so I just kind of assume, I predict that they would be able to sort through a lot of those connections and connect the dots and be able to identify somebody relatively quickly on in the process. But as time had dragged on, yeah, I wasn't really expecting an arrest when it happened. So I think the combination of just an enormous amount of relief, oh, thank God they finally got the guy, and then the way that he came to our attention, just splashed all over international media. His face is being put next to Ted Bundy's face. He's being shown in his bulletproof vest and things like that. I'm just not really sure there were any circumstances where he could have been presented where we would have thought, oh, I don't know, he looks kind of innocent, That's my read on it. Obviously everybody is certainly entitled to their perspective and to their read. But one of the things I've said many times, and I will continue to say, is that at least in terms of demeanor, the way that he behaves in the courtroom, he does not behave like somebody who I would expect, had committed murders like these, which appear to be kind of disorganized. At the same time, they're also, under the state's theory, extremely organized. But typically, brutal, murders like this, it's a disorganized, it's an impulsive, it's a passion, kind of killing. You don't expect that person to be extremely well behaved in the courtroom. You just don't. So take that for whatever you want, or nothing at all. I mean, again, that's just my perspective on it. But I understand people have this perception of him, and that is going to be a massive hurdle for him to have to overcome. Once again, we come back to why my preference, everything else being equal, I want to put my client on the stand, because people have all of these ideas about him. And if he is not that at all, I would want them to know that. I would want them to see. I would want them to see if he presents as a very respectful, very normal, very congenial, see him smile and interact with his attorney on a human basis. If he's able to do those things, yeah, I would like them to see that, in part because I would want to be able to explode some of those myths, these just imagined ideas people have about who he is from what they've read. Sky is a neighborhood. How do they work out the length of trials, Andrea? So basically, like you've seen, they're typically going to have talked to both sides. I mean, they will have input on how many people do you expect to call, how long do you think it's going to take you to get through all of your experts, all your percipient witnesses, and so forth. So it is usually collaborative in that sense. But it can be a little bit of a guess. The parties are guessing just based on their trial experience, how long they think it will take them to go through. And giving a good faith assumption that the other party isn't going to be, I don't know, dragging their feet, doing weird things, lally-buying us with a lot of nonsense. That cross-examination and stuff is going to be done in good faith and fairly targeted. You can usually estimate, pretty closely. These are obviously very experienced attorneys. They've been to trial all kinds of times. The judge as well. He's presided over all kinds of trials. So they just give it their best estimate, and hopefully they're right. Hopefully they're right. I don't think Judge is the kind of judge who would put like a hard limit on, here's how long we said it's going to be, and we're gonna like shut off the trial at the end of week 8 if they're not done. That is a very hardline approach. We're seeing that from Judge Gohl over there in Delphi, where she set a trial date October to November, and it's hard. I mean, I think she's made it pretty clear that's gonna be it. Like, they're not gonna go beyond that. The defense is not happy with that, which I understand, because trials are fluid. Things can change. Your rebuttal, your rebuttal evidence can really change a lot depending on what comes out at trial, what people say, do they change stories, just all of that type of thing. So having that sort of hard fixed schedule, while on the one hand, you want that for the court's convenience so they can arrange the rest of their hearings and things like that. They can arrange their own schedule. And you certainly want it for the jurors. You don't want to, have the jurors expecting that they're only going to be there for so long, and then it turns out, it's going to drag out. Seeing a little bit of that in Karen Reed too. This trial went longer than the jury had been led to expect. So we had that whole issue yesterday with the jurors wanting to be sure that they could leave by 4 on the bus because somebody had a long-standing pre-scheduled appointment. So you want to avoid those types of conflicts, and they just will draw on their experience, their knowledge of what they intend to present in the case, do the best they can to give it a best estimate, and hopefully they're generally in the ballpark. Squinting Cat, important question. What lip color are you wearing? I would have to go look. Honestly, this is an old one I've had in my drawer for quite some time. I just was kind of trying to match my little Phillies hat here, my little throwback. I love my little retro Phillies stuff. It's like the best era, the 80s Phillies stuff. The powder blue with the retro P is like my favorite thing. So I'm sorry I can't give you an answer just right off the top of my head. It's something old, probably couldn't find it. It's nothing fancy. But I'm glad you like it. I do like a good berry, and occasionally a little bit of a jewel tone. Kirsty, listen to the prosecutor's coverage of Karen Reed this morning. They described Bev as a great judge. I just about spat out my coffee. Well, the thing is that, of course, a judge who is extremely friendly to the prosecution is going to be seen by the prosecution as a great judge. I mean, that seems extremely unsurprising, to me. From my perspective, a great judge is a judge who gets it right, and so that means the judge makes the correct rulings. They don't get overturned on appeal very often, and that is not Judge Bev. I did point out that ruling for the prosecution has not been what's gotten her in trouble on appeal. It's been ruling for the defense. So, one might challenge then or critique the argument that Bev is particularly prosecution friendly. But in the context of this case, it seems really hard not to come to that conclusion. The way she was kind of treating them yesterday. Now, I understand it's been a long trial. These folks have had a lot of interactions, and they have their impressions built up over time. If the defense is in there feeling like they haven't been heard since before they even got into trial, that frustration is going to build as it continues to interfere in their perspective with their ability to present their case, their ability to defend their client, their ability to present arguments to the jury, and their ability to have a fair deliberation with the clear options for what the verdict is supposed to be on the greater and all of the lesser included offenses. So that likely goes both ways. You know, Bev has seen the parties and how they have handled themselves over the last several months. I am sure that she has her own views of, you know, what the defense has done and what the prosecution has done. She clearly seems, from the things that she has said, to be pretty negative on the defense. My turning point for Judge Bev was when she was just quite nasty to Mr. Yannetti on that late filed, you know, during the middle of trial prosecution motion to exclude the defense experts. And she made this snide comment about, you're arguing to me, you're not arguing to the cameras. That was a turning point to me, because it's not necessary to be snippy like that. And when it becomes evident that you're being snippy with the defense over raising arguments that they have to make, and you know, you can't understand why they'd be outraged at being sandbagged and having their positions misrepresented and so forth. I just don't think you're being very fair to their perspective. When, on the other hand, the prosecution is asking you to do things that should be laughable, they should be absurd, that they would even think to suggest that Karen Reed trying to hire an attorney is consciousness of guilt evidence. She's complimenting them for that. You know, we're not getting that same even-handed just perspective on what she's getting from both sides. So that's, you know, it doesn't really matter who you're biased in favor of at any point in time. The problem is that when you are biased in a case as a judge, it affects your ability to make good decisions, because factors that don't affect what the law is or how the law applies to the facts in your case are driving your decision-making process. So that's what I don't, you know, that's where I don't agree with Judge Bev being a great judge. She's not, because she's not even-handed. And even if historically she's been even-handed in ways that are beneficial to the defense, it's gotten her into problem. Her lack of impartiality has gotten her into trouble in the past. And so just because we have a little bit of a role reversal in this case, doesn't mean that it isn't still a problem. It's the same issue. It's just, you know, for whatever reason, it's playing out with the different sides at this point in time. Cindy Moore, 13. Any chance you can provide some reassurance re Karen Reed verdict delay when you're done with Kohberger hearing? Of course. Patience. It can be a long process. We heard in the instructions themselves, the judge is telling them you need to go through everything before you decide, before you even take a straw vote. Not that she's like directing them, you absolutely have to do it that way, but, you know, making it clear that's the preferred process. And so, yeah, there is a lot for them to go through. We had the opportunity over 9-10 weeks or whatever it was to look at all of this, to vent to each other, to, you know, oh my God, can you believe they did this? To put our heads together and get a sense of where we have consensus on things. And the jury has only just been able to start that process. They have so much to do to come together and form a unified perspective. So I would not worry at this point in time. Acquittals, I know that for people who see the evidence very clear, and I confess I'm one of them, you know, for me, a not guilty vote would not be difficult at all, just from what I've seen. And so you have the expectation that, it's just going to be fast. It's going to be very easy for them. Fast acquittals are rare. They're rare, especially with serious charges, because the jury wants to be careful. They want to be careful. They want to get it right. They want to be sure that to the best they can, they understand what happened, what's been presented. They haven't missed anything. And there's been a lot of stuff presented to them that is in evidence that they've only seen small parts of. So if they are being diligent in wanting to sort through everything, there's quite a lot there that they would have to go through for the first time, because it wouldn't have been shown to them in the courtroom. So no, I don't think there is cause to worry at this point in time. I would not personally start to worry unless we get an indication that the jury is deadlocked. And even in that case, you know, a hung jury, while I consider it rather a win for the Commonwealth in this case, you know, it's not a conviction either. The common wisdom generally is a hung jury would be favorable to the defense because it's not a conviction. The jury could not have been, you know, unanimously convinced that she did anything wrong, even with, you know, lesser offenses and things like that. So it's just, it's difficult because we are in limbo and we're on pins and needles and we're waiting, and it's a very uncomfortable position to be in. But we just have to have patience. It is a process. It's not an easy one. It's not a fast one. And it's good. It's good for the jurors to be diligent, to take their time, review everything that they need to review, and be sure about their decision. Duncan, Idaho, I just think it'll be an interesting opportunity to examine biases on the tail end of the Karen Read trial, where I am sympathetic to defense versus this, where I am sort of unnerved by the defendant. Thanks, Andrea. Well, you're very welcome. I mean, we're all subject to these things. You know, we're all subject to these biases and these preferences. And that's, yeah, why the trial process is so important to wait and see what the evidence actually ends up being. Which brings me a little bit to this new book that's out there. This guy, I don't even want to say his name because it's like, why would I want to elevate more of this? New book that's out that even the Gonzalez family is calling a fiction. It's fiction. It you know, purports to be based on sources that are reporting like conversations that the family, Bryan Kohberger's family had and things like that, that are not consistent with the statements that Bryan Kohberger's family has publicly made. They publicly made at the time of his arrest that they stand by him, that this is not in character for him. They certainly have sympathy for the families and the families of the victims and what they've gone through. But no, they don't think it was him. They made that pretty clear, and they're just waiting for the process to play out. So I'm very, very skeptical that this new book is anything but just more of the same, largely, you know, fictionalized accounts reaching for information from anonymous sourcing that can't be vetted. We don't even know who it is, so we can't judge the quality of that information. We already know there's been a massive amount of fiction that's just out there in the media. That an enormous amount of what the media has reported has been simply not true. We heard quite a bit about that. In the motion to change, not the motion to change venue, but the motion to shut down the surveys relating to the venue issue. Because some of the specific questions, they made it clear on the record in court, everybody, including the judge, that they were not true. The reports that Bryan Kohberger had stalked the victims, not true. Not true. They made that clear. And that's building on what we already knew from these defense pleadings. They have no evidence of any connection that he ever had with these people. So I don't have any reason to think this is anything but just more of the same. It's low quality information. It's opportunistic reporting that's just seizing on a collective perspective that has been shaped, whether deliberately or just incidentally, because it worked with the media narrative and everybody wanted so much for this crime to be solved and over, and nobody wants to think about the possibility that if he isn't it, then the person who did it is still out there. The person who did it is still out there if it's not him. Nobody wants to think about that. So there's just very, very powerful incentives to think that it's him and to craft narratives that support the idea that it is him. So I'm going to be very, very interested when we get to trial and what actually turns out to be true and what turns out to have just been fiction the entire time. William Hughes, if change of venue will judge remain trial judge. So he has the option in Idaho. It's up to him. It's discretionary whether he keeps it or whether he goes with it. So we don't know. It will be up to him to make that decision. I have in the past suggested that I kind of doubt that he would, because he's the chief administrative judge for his judicial district in Idaho. And so that just means he's got responsibilities to other judges, other courts, other processes beyond, his role as the trial judge over this particular proceeding. The fact that Latah County is a small county, he is the only district court judge. They have a commissioner who can preside over, kind of lower seriousness proceedings, but like felony charges, they go to the district court judge, and he's the only one. So that means if he's gone for 3 months, they're going to have to bring in temporary judges to fill in for him. It creates more of a burden from a kind of practical court administration standpoint than just handing it over to, for example, Ada County, which is kind of where I think most people are predicting it would be likely to land if venue does get changed, although that's not a guarantee. Ada County, very, very big, lots of judges, just going to be in a better position to be able to accommodate that type of issue. So ultimately, it will be up to him, but I tend to suspect, no, he would not go with it. It's me, Mario. My Guardians will see your Phillies in the World Series, lol. See you there. I gotta admit, it's just been a great year to watch the Phillies. It's been a great year to watch the Phillies. Not always a great year to watch baseball. Last year, this part of the baseball season was excruciating. It was so painful to watch. They were terrible. They were terrible. They stumbled right out of the gate, struggled to get to 500. I don't think they hit 500 until after the All-Star break. I mean, it was bad. It was a mess. And so it was their late season run was the only thing that like redeemed last year. This year, it's been wonderful. It really has. And, best record in baseball. And we just really hope that that can last, because I would definitely love to see you in the World Series. Jessica, please tell me what the federal jurisdiction is. We see them in RICO and sex trafficking and things crossing borders, but what is their jurisdiction over states, state agencies, local agencies? What charges can be brought? So yeah, federal jurisdiction is limited because the presumption is that crimes are local matters. Most crimes are local matters. They've conventionally been handled that way. The area where the crime was committed, that those are the people affected. Those are the people with the access to be able to do it, to do the investigation and stuff like that. So it's just even back to the common law, that's conventionally how it's been. So federal jurisdiction over criminal matters in general is typically pretty limited. And so it's very specific grounds that Congress has adopted that justify feds prosecuting somebody criminally. So yeah, you've identified some of these. There's a few different ones. Quite a few different bases, like a lot of white collar crime, interstate types of fraud activities, things like that, the feds tend to get a lot more involved in. But what I think we're getting at here with jurisdiction over states and states agencies and local agencies is corruption. The feds very much have a key role to play in investigating institutional corruption, because these are federal crimes. You know, being a politician who is taking bribes, being a law enforcement agent who is, abusing their position, violating people's rights and things like that. Particularly if there's an indication that this is something systemic. This is not just one bad actor. This is something that goes to the entire department, the entire unit. Then it's very common for the feds to get involved and to be overseeing that process. Even if it's, not necessarily like, are we looking at a crime? Just an example I would give, there's been a lot of recent, honestly, recent, it goes back quite some time now, it goes back some decades now, but oversight over policing, federal oversight over, are there problems with law enforcement agencies kind of routinely violating people's rights, routinely just engaging in behavior that is excessive, is potentially corrupt, is not even-handed as far as, the equal protection rights of the people that they're policing, and so forth. And so if it's just a bad actor, the department would take care of that, and it's not likely that the feds would step in that situation. But it's when the entire department is tainted, then you have a problem. And that's when the feds, they have gotten involved historically. There have been a number of cases of consent decrees that law enforcement agencies have entered into to address some of these problems that the feds have identified with policing practices. Seattle Police Department is one here in my state that I'm familiar with. We're under a consent decree for quite a considerable length of time. So that's basically the connection is when there is some kind of institutional either corruption problem or a systemic violation of civil rights kind of problem, an equal protection kind of problem, the feds will get involved at that point. Not always, but they do have jurisdiction to look at that. Everage, after anti-Bev, JJ is a breath of fresh air. Exactly my thoughts. Exactly my thoughts. Might not love everything about him, but my goodness, somebody who is fair and courteous to everybody in his courtroom. Yeah. Real breath of fresh air. Mike Dorado, any thoughts on guy that wrote the book BK? I don't know if this is getting back to the guy I don't want to mention because I don't really want to elevate him. And if you're following this, you know who it is anyway. Or if this is another specific book, I'm not sure. I'm just in general very skeptical of any book that is coming out before the trial process because the information is so limited and everybody who would be in a position to know is under a gag order. So they're jeopardizing the prosecution. They're jeopardizing, being found in contempt. If they're leaking and it gets back to the court. It's kind of hard to imagine that if somebody is giving information to a journalist or to an author that, enough to support a book, that they wouldn't be able to figure out who that was, to trace out, well, who would have access to that information and so forth. So I'm very skeptical of all of it because we're in an information vacuum at this point of time. We don't know the whole story. And it's just, I just don't think it's very likely that, that any of these journalists who come in and can't even, they don't know the community. They don't have connections to the community. They don't even pronounce the names right, I'm not saying there's anything wrong with that. Like, it's not like you're an awful person if you don't know it's Moscow. I didn't know it was Delphi and I thought it was Delphi. It's Delphi in Greece, but I understand there's local local conventions for this type of thing. But I'm not out here trying to like gather sources and be, be presenting facts that nobody knows, that somebody tells me because I'm so in. I'm very skeptical that somebody who doesn't know it's Coeur d'Alene is talking to people in this area that would be in a position to know that type of thing. So overall, I'm skeptical of pretty much all the books. Z, thoughts on KR verdict form issue and Bev behavior? Well, yeah, so this is one of the things that came up yesterday, and I did not like her demeanor. So what happened was we had a number of times where the court came back into session yesterday, but nothing really substantive. The first issue was the jury question where they wanted to be able to get on the bus by 4 because somebody had an appointment. The second time was when Mr. Jackson had, I think, asked that court come back into session. And so really from the outset, you could see that Judge Bev was peeved by this because she's like, I don't know why we're here. What are we doing here? She has this very just negative response to coming into session to have to deal with something in the case. Mr. Jackson has a concern with the jury form. I also have concerns with the jury form. My concerns are slightly different than the concerns that Mr. Jackson raised, and I remain concerned about my concerns. It I'll start first with what Mr. Jackson's concerns were. Basically, the way the jury form was written, it just basically said it gave them options for their verdict, and the options basically said for voluntary manslaughter. This is all dealing with count 2 and the lesser includeds to count 2. Voluntary manslaughter, you find him not guilty, and then for all of the lesser charges, it was only the option to find her guilty. There was no box for them to check to say they find her not guilty. Well, Mr. Jackson didn't like this at all. His perspective is you're pushing them towards finding her guilty because they don't have a box to check. They don't have an option to find her not guilty of any of the lesser included offenses. And Judge Bev was arguing with him, took umbrage at that, and well, it's right here in the form, and they would just leave that blank. And Mr. Jackson's like, so we're supposed to take a blank form as like a verdict? I mean, it's problematic in that respect. But Judge Bev then kind of put Mr. Yannetti on the spot. Well, Mr. Yannetti, you practice in Massachusetts. You've seen this before. And Mr. Yannetti says, I haven't seen this before. I got to tell you, I haven't. And then she gets kind of snarky with him too. Are you telling me you've never seen lesser includeds? No, I have, but I've never seen this form. So I took issue with it in many respects, the way that Judge Bev handled this hearing, because it seemed pretty clear she was on notice that the defense had concerns about this form and that they had asked her to, I guess, maybe take a look at it, reconsider it. And that apparently had not been done before the form went back to the jury. So Mr. Jackson is unhappy about that. He was clearly under the impression that she recognized there were issues with the form that they were going to have to address. And Bev's response is, no, I just said I was tired and I would think about it. Nobody wants to hear about the judge being tired. Everybody's tired. How tired do you think the jury is? How tired do you think the jury is, and how tired are they going to be having to sort through what the heck they're supposed to do with this verdict form? And then there was just that final conclusion where she has been dismissive of the defense perspective throughout this argument. She said, no, I never said I was going to do anything. I said I was tired, and I think it's fine. Mr. Jackson, I think, is getting increasingly frustrated because she seems unwilling to hear him. Which is very frustrating, when you're in front of a judge and they just have this wall up. Like you literally could be talking to a wall at that point. You're just there to make your record. You have no expectation of actually being able to connect with and convince this person who's up there with all of this control over how your case is unfolding. Karen, I think, made some kind of expression, probably, incredulity, like, I do. What are you going to do? Are you going to cry in court? No, you're going to laugh. It's it's a coping mechanism. It's just unbelievable sometimes, what happens if you feel like you're being fairly untreated and, wow, isn't this consistent with what I've come to expect in this case? And then Judge Bev, cuts in. Is there something funny? Something funny, Miss Reed? We're done. Not well handled by the judge, in my perspective. Negative to having the hearing from the outset. She had been on notice that it was an issue. Didn't apparently seem to communicate to the parties what, if any, decision she had made about this, and yet the form has apparently gone back to the jury without any kind of modification to it. I'll tell you my suspicion. My suspicion is she forgot she was supposed to look at it. She just forgot. And so then she was defensive when Mr. Jackson came out and raised it because, oops, I was supposed to do that and I didn't. And so she just dug in because of the fact it had already been sent back, and she can't possibly concede any kind of error on her part, right? Throughout this whole thing, there's been nothing but just how well founded in the law her decisions are, and no error and so forth, which she then reiterated when she came back into court after they had a jury question. This is the third time the court came back into session yesterday. Jury had a question, wanted to see the cert report. There is no cert report, and certainly not in evidence. So the only answer the judge can give them is it's not in evidence. You already have the evidence. That's what you have to consider. But then she revised her position on the jury instruction. Not only are there problems with just the language, the confusion about how it's supposed, how the process is supposed to be to unfold in the jury room with considering these different alternatives. How are they supposed to work through them and stuff? But also problems with like misspelling and formatting and things like that. So my suspicion, yeah, she got mad because she oopsed. She was supposed to look at it. She forgot. She didn't. It went back to the jury room. Soon as she gets off the bench after snapping at Karen, she's like, oh shit, better go look at that. And then she did and realized, okay, yeah, maybe there are some issues here. So they did revise it, and she made a point of saying, I'm not saying the first one was legally perfectly correct, because she doesn't want to concede there was any problem with that first one going back to the jury. But in an abundance of caution, she would give like 10 more pages of instructions to the jury about just how to work through the lesser included offenses and decide each of them. So what it came down to is they modified the verdict form to include language under the not guilty section, that it was basically clarified. It's not just not guilty to the voluntary manslaughter charge. It's not guilty to voluntary manslaughter or to any of the lesser included offenses. So then you very clearly have a not guilty if they find that on all of the lesser included offenses. That's what Mr. Jackson requested. She went along with that, and he indicated that they were satisfied. I'm not satisfied with that solution because it doesn't get to the problem that I see with this form. The problem that I see with the form is with the form, period. It's not just the version of it that went back to the jury. It's the form that they use in Massachusetts under these types of circumstances. And the reason why is because it goes to double jeopardy considerations. Anytime the jury considers a charge and decides unanimously she's not guilty of that one, and then moves on to consider a lesser included offense, they can't retry her on anything that the jury has said she's not guilty of. And the verdict form doesn't give them an option to be able to work through those lesser included offenses and decide individually, indicate, we've decided she's not guilty of these. And the reason why that becomes a problem is because if they work through, say they decide she's not guilty of voluntary manslaughter. We look at the first lesser included, the involuntary manslaughter. We think she's not guilty of that either. They get down to motor vehicle homicide and they can't decide. They're hung. Because what they're hung on is the issue involving her mental state. They can't decide. Maybe some people think, yeah, she did it, but it was an accident. She didn't mean to. It was just, bad conditions and whatever. Other people are like, no, she really didn't hit him with the car. They're in a deadlock over that, so they can't reach a verdict. There's no way to indicate on this form that they have acquitted her of those higher offenses because she cannot be retried on them. So that's the concern that I have with how their form is written, because if, heaven forbid, we have a hung jury here, they hang on that second count, that's gonna create issues. It's, in my mind, going to create issues over whether and what they can retry her with. Because it doesn't give the jury the opportunity to say it's not guilty is all or nothing. And the options available to them in their deliberations are not all or nothing. So if they follow this form to the letter, the way that the form is written, they cannot indicate she's not guilty of some of the greaters, but they can't decide on one or more of the lessers. There's no way to indicate that on the form. The form would go back blank, and then the blank would seem to indicate they can retry her on everything, including the primary charge of the manslaughter, the voluntary manslaughter. So that's a big problem that I see with this particular jury form. That has not been addressed by this modification that they made to it yesterday. But now it's not been waived. It's not been preserved. That issue has arguably been waived. So just a real potential problem there if we get a hung jury. Hopefully we don't, and then it's a non-issue and we don't have to worry about it at all. Marcia, do you think the jury is trying to figure out cover-up rather than did she hit J.O.? No proof of her hitting him. I don't know what the jury is doing, but my suspicion is just they want to be as informed as they possibly can. It's not technically their job to decide what happened, solve the crime, figure it out, figure it all out. It's not really their job to do that. Their job is just, has the prosecution met their burden of proof? But it's very normal and very human to want to know as much as you can before you make that decision, So I don't have really any reason to think at this point that they're doing anything else. They wanted the cert report, so they're clearly looking at the process, the evidence gathering, the police investigation, but we just can't know what they're thinking about that. We can't know if they're thinking, are we trying to resolve the 3 versus 5 pieces of plastic type of thing? Are we trying to resolve who are the unknown people at the scene kind of thing? We don't know what their thought process is. It could just be, they just want to know as much as they can before they have to make that decision. KB, as I understand, in the US, you have common law, and in Switzerland, we have civil law. Is there a big difference between these two kinds of law? Yeah, there can be. So we actually have in the United States, Louisiana is not a common law jurisdiction. It's a civil law jurisdiction because it goes back to the French colonial system. The main differences are just sort of civil law is specifically enacted. Like if the legislature hasn't adopted it, it's not law. In common law jurisdictions, no, we go back to old history and tradition. Sometimes, all the way back into common law England for things dealing with like property rights and just a variety of situations where that type of thing can come up. So it's relying much more on just a convention, which can make it a little bit more obscure. From a practice standpoint, civil law jurisdictions can be a lot easier to deal with because there aren't as many surprises. The law is just right there, and you know where it comes from, you know where to go look for it, and if it's not there, you can kind of safely assume it doesn't exist. With the common law, it's much more difficult because there can be practices, there can be rules, there can be all kinds of things that you don't know about. They're just kind of part of the tradition that this jurisdiction has continued to follow from way back when. I found this a bit of a challenge in Depp versus Heard because in Massachusetts a little bit as well, although Massachusetts, so they they don't technically have rules of evidence, for example, because it's just based on common law. It's based on the history and tradition of how evidence has been treated in the courts, from all the way back to England, and got imported into the United States, and then has been done since then. So they have guidelines that the Supreme Court has adopted that are very similar to what we would all consider evidence rules, but they're not evidence rules that are in and of themselves binding. They're just a compilation and a summary of what the common law is. In Virginia, I found it very challenging just because, many of their processes and things that they do, it's very obscure. If you don't know that location, you don't know specifically what they rely on, it can be a real challenge to try to sort that out. So not nearly as outsider friendly as, from my perspective, the civil law jurisdictions typically are. Jessica, thank you for your in-depth answer to my question. Well, you're very welcome. Always happy to answer questions. Do my best to just give you the best information I can, how I see things. Amanda Lang, entirely unlikely hypothetical. What would the legal implications be if jury hung and only guilty vote was the foreman the judge selected? So first off, there would be no implications. None. Unless they could prove actual proof of bias or interference with the process or something like that. Not just it looks bad, not just it looks shady. That's not going to be enough. It's not going to be enough in this type of context. You're going to have to prove judge set it up. And that's a very, very, very difficult burden to meet. We are unlikely to even know who voted what in the case of a hung jury. You typically don't ask. You might maybe get a breakdown of where the votes are at, just because sometimes they'll ask to get a sense of like, how deadlocked are you? That can shed light on how likely is it that you're going to be able to resolve it and come in and reach a verdict anyway. So sometimes you'll get the split, but other than that, it just depends on if the jury wants to talk afterwards. They can disclose what's going on in the jury room if they want to, but they're under no obligation to. And the court is typically not allowed to ask a whole lot of questions about what's going on in the jury room. They're limited pretty much to asking about misconduct, if there is misconduct. And even that, they tend to tiptoe around about what the substance of the deliberations are. And that's just because the process is intended to be protected for the benefit of the jurors, to be able to do what they need to do without outside scrutiny, without judgment. They are really the sovereign in the trial process. So their decision-making process, it really doesn't get to be questioned, as long as there's no evidence that they are breaking the rules or something like that. So it's unlikely we'd find out who was voting for what. But even if we did and we found out it's the foreperson, there would be none. There would be no consequences for that. Just saying it how it is. They would go and they would retry it just like they would retry any other case where the jury hung. Track worker, not an oversight. It was intentional to confuse jury. It was a little bit strange how the form language, again, granted that the form language doesn't address my particular concern. Nevertheless, there is that form language that Massachusetts normally uses for the not guilty, that it's not guilty of the main offense and any lesser included offenses. It was a bit peculiar that was omitted from this form. I don't know why. I don't know who prepared this form. That's one of the, I guess, questions that I would have about it. Where I'm from, normally the prosecutor does all of it. They prepare the jury instructions, they prepare the form. The defense will sometimes propose their own specific instructions. Sometimes the defense will propose their own form, but the preference is really for the defense to propose as little as possible, because anything you propose, you can't argue about later if it's wrong. Like even if, 10 years down the road, the law changes and it turns out this instruction that that was given in your case is completely wrong and sent the jury in a totally wrong direction. You, the defense attorney, proposed it. It's invited error. You don't get to argue that on appeal. So defense attorneys typically try to minimize how much of the instructions and the verdict form they actually contribute to. Some places the courts will do it themselves. Now, we saw that the prosecution did propose jury instructions in this case. It wasn't a complete set. So if the court prepared this instruction, that is a little alarming to me, because I don't have a good explanation or understanding of why you would eliminate that form language that that makes it clear at least what they're voting on, even if it's pitched as an all or nothing decision that it in my view should not be. Nevertheless, it does make it clear that by checking this box, you are also ruling on those lesser included offenses. The form that they were given initially, it really did not make that clear at all, because that guilty, it seems to be, it's if you just read the language and how the language works, it's a guilty only or not guilty only to that primary charge of voluntary manslaughter. So, I mean, it was confusing. It was confusing, and the source of that confusion, don't love it. Don't know what it is. Don't know what it is. I don't put it past prosecutors, typically to try to be confusing, to try to cut corners and gain little advantages like that. Obviously not everybody, but from what I have seen of Mr. Lally, would I expect that from him? 100%. A guy who will misstate the evidence at closing, who will present, mirrored, arguably falsified evidence to the jury without disclosing what it is, creating this misleading impression about it. Would I expect that guy to try to gain a little advantage in the verdict form? 100%. Yeah, I would. Yeah, I absolutely would. If this verdict form was drafted by the court, I don't like that at all. Not one bit. Rube, does jury have ARCA report? Was it admitted? Neither defense experts, MDs, wrote reports, so jury has nothing from defense to examine, and boxes of BS reports, etc. from the Commonwealth. So almost none of the reports have gone to the jury. Reports typically are not admissible as evidence independently. They are hearsay. They are out of court statements made by the witness. So it's the witness's live courtroom testimony that is what the jury is allowed to consider. So to the extent that reports have come in, it's very limited. And it's typically for a purpose because it was used to impeach with like a prior inconsistent statement or something along those lines. So they don't have the ARCA report, but it's not like they have all the police reports that were written and stuff in the case either. They don't have that. They're going to have, for example, the catalog, because the defense brought that in because it shows the timeline of the arrival to the scene and who came in what order and stuff like that. That whole initial cross-examination of Officer Seraph, we got to think way back into the early days of the trial to pull on that one. But that was the first thing that the defense had pointed out. Every single thing in that catalog was wrong. And so that's the type of context where they will get reports and things like that. They don't have an abundance of paper filing from the prosecutor either. Did the Commonwealth prove she hit him with a car? Q1. Did the Commonwealth prove she hit him with a car? A, no. Q2, no other question needed. It is really just that one fact. Said it before in chat. I hate that the government can do lesser included. They should not have that option. To me, it's this simple also. It really is. It's the one common thread between all of these charges. She had to have hit him with a car. And so if she didn't do that, then it should be over. And really, it's if the Commonwealth didn't prove she did that, it should be over. I think the concern would be that the jury is trying to consider all possible alternatives. Is it possible that maybe she did just nudge him and he fell over and hit his head and left a little bit of taillight at the scene. And then maybe Trooper Proctor just kind of went overkill with trying to make sure she didn't get away with it, and you know, sprinkled a little more around or something like that. That's where I would be concerned, is that the jury is trying to consider like every possibility and rule those out for themselves. So in that scenario, you know, can they conceive of a situation where she did hit him with the car and it's consistent with some of what we saw, like maybe it would just push him or cause him to slip or something like that, and that's why he's not bruised? And then the dog got out and bit his arm. You know, you can always, I mean, pretty much always, you know, dream up a scenario that will fit any particular set of evidence that you have to work with. It's not the jury's job to do that, but they are, again, they're human, and they want to be confident in their decision and that they're doing the right thing. So I can't, you know, fault them if they are trying to be thorough and rule out every single possibility for how these events could have unfolded to produce this evidence before they reach a final verdict on it. As far as the lesser includeds, I don't like it either. They have the power to charge. If they want the possibility of a lesser, they should charge it. It shouldn't be a let's get through trial and evaluate how we feel about how we did at that point in time, and what other fallback positions we might be able to have if things didn't go the way that we hoped or expected that they would. So I don't particularly like it either. You know, the rationale for it is just that, well, it's not unfair to the defense because all of the elements of a lesser included offense are necessarily included in a greater offense. So if the defense is prepared to defend against the greater, they're necessarily prepared to defend against the lesser as well. I don't always agree with that because defense strategies can differ depending on what is the precise point that's in dispute in the case. But that is the general rationale behind it. So I don't like it. Some cases, some states will not allow the prosecution to propose lesser includeds. Only the defense can. I like that. I think it's fair. I think if the prosecution wanted the lessers, wanted that on the table, they should have charged them. Bassam Ramadan, I successfully defended my PhD in construction engineering yesterday. Congratulations. Not to be confused with reconstruction. Your recent KR coverage has been a great distraction from all the stress and anxiety. Thanks. Well, you're welcome, and thank you for joining us. Glad we could give you a little mental break. Never had to defend a PhD dissertation. That sounds like a lot. I know that's a culmination of a massive amount of work and preparation, and so kudos to you for getting through that. Yeah, construction engineering, not to be confused with reconstruction. You build big things. You make sure that they don't fall down. Thank you for making sure the skyscrapers don't fall down on us. You're the real MVP. Duncan, Idaho. AJ's fire at Judge Bev, you love to see it. He's just done. He's had enough. We started to see it come out during the trial. He's had enough. He doesn't think he's fair, and he's tired of having to pretend like she is. And so he's dropping the pretense of deferring to her because she just will not budge and be even-handed. So I don't know if it's always a great strategy, but there's a human element to it. And obviously it didn't stop her from coming back and fixing the instruction once she took a look at it. Oops. Yeah, maybe should have tweaked this. Didn't stop her from doing it. So it's like, guess if it didn't hurt anything, maybe he should go ahead and continue to say it how he thinks it. KB gifted 5 Andrea Burkhart memberships. Thank you so much. Mobilis. I don't always know which syllable. Which syllable is it? Mobilis? If the defendant is presumed innocent, why does an acquittal have to be unanimous? That's a good question. It's just because if the jury does not reach a unanimous decision, she's not convicted. So she continues to retain her presumption of innocence. It just hasn't been definitively established. So if it hasn't been one way or another, then she's certainly not convicted, but the presumption hasn't been overcome one way or the other. If they don't have unanimous agreement on the decision. Angie Hammond, if the jury has a turtle boy and a coffin dapper, then this is what could be taking so long. Absolutely. You don't know who's in there, what their perspectives are, and how they've seen things unfold. You just don't know. It's always been the challenge of this particular defense, the third party culprit defense. Nobody wants to believe a frame up. Nobody wants to believe a conspiracy. There are people that look at this case, and no matter really what the evidence has come out to create the inference that this is a pretty good explanation for what happened, people will refuse to believe it. It just seems too incredible, It seems too incredible. I think that may be part of what Mr. Kohberger is dealing with as well. It just seems too incredible that he would get targeted as the wrong guy. But my perception of how that happened is just it's very natural. It's very natural. They found the trace DNA. The trace DNA on the knife sheath, which is not particularly good evidence of like provenance or connection to the crime scene, to the murder. I've talked a lot about the problems with trace DNA and how transferable it is, and we even heard some of that in Karen Reed. In fact, even the prosecution brought up transfer DNA before we got into how many people's DNA was all over John's clothes. All over the blood stains on John's clothes. So yeah, but it was the probably most direct piece of evidence that they had to work with in the sense that it would give them an identity. It would give them a person. And so that's how something like this can unfold. You get that piece of evidence. You're like, wow, what a coincidence that it ended up on this knife sheath. I mean, not really, because people have touched the knife sheath. It's honestly not that big of a coincidence, but it just maybe seems like it. And so, yeah, once they could tie that DNA to him, the rest just became a process of let's try to fit everything. Let's try to fit it. Let's try to fit his location. Let's try to fit his actions. Let's try to fit his background and his education and everything to make it him. And the problem is just that it seems to be coming out that it may not be a very good fit. Pandora Fox. Meanwhile, sadly, a man has died. Curious that the McAlberts are more interested in defending themselves and threatening TB than grieving for JO. Is it surprising? Is it really? Given what we saw from them on the stand? Is it curious? Or is it exactly what we kind of expect? This whole trial, you can certainly see it through the lens of this was a defense of the McAlberts. This was not an attempt to prosecute Karen. This was an attempt to avoid that suspicion from falling on those people. But it is unfortunate. I would I can't imagine a situation if something like that happened to somebody I loved, somebody in my family, somebody that I cared deeply about. I just can't imagine going to court with the people that destroyed their phones. The guy who destroyed his phone Oh no, wait, he just traded it in. He just upgraded his phone 3 weeks after his birthday, the day that the court is having a hearing on whether you need to keep your phone to turn it over as evidence. I wouldn't do that, but I guess that's just me. James Brown, I was dead wrong. Oh, James Brown set the over-under for us at 3 hours. I understand. We all, I think, were a bit optimistic just because the overwhelming majority of us, I think, all do see the case the same way. But there are still people out there that don't. I think it's a small minority. I think if you go look at, like, there's a poll on Court TV, even polls on law and crime. These are not, echo chambers or anything like that. People from all across the spectrum are watching on those channels. And they are pretty overwhelmingly in favor of not guilty. But that doesn't mean there are no people that think she's guilty. So, not that unreasonable, not that unexpected that there would be some of them in the courtroom. KB, I find it hard to believe BK could kill 4 people in the short time with only 1 knife and all by himself and not leave a trace and not track any of it into his car and have done all that without any sort of digital footprint to the victims that would put him there, that he would take his phone, the digital forensics guy. There's this whole argument that, oh, well, he because he studied criminology, he would know how to prevent DNA transfer and stuff like that. He's the digital forensics guy. He would know not to bring his phone. I mean, just the absolute basic thing is the thing he didn't do. It's just so, the explanation to me does not really make a lot of sense. It just doesn't. It just doesn't. We don't have a why. Not that you need a why, but a why is very helpful to understand. We don't have a why. We don't have a we don't have a how. We don't have a time frame, really, other than just, well, police think it was this time frame, but how much of that is driven by the fact that they saw the white car outside and they want the white car to be connected? How do we even know the white car is connected? They don't tell us. Just they think. Why would somebody drive their own car? This guy that's supposed to be all educated. This is what I mean when I say it's this very incoherent of both the most organized and disorganized crime ever. Because when I use these terms, I'm talking about there are this goes back to the federal FBI has, they profile offenders and things like that. And part of that is based on characteristics of the crime. And so one way of categorizing crimes is, are they organized or are they disorganized? Disorganized crimes, they tend to be impulsive. They tend to be messy. There tends to be less effort to prevent detection. Organized crimes, they are planned. They are dispassionate. They are details are worked out. Steps taken to cover the tracks. All of those types of things. This is just a very bizarre seeming combination of both, where, he was so overcome with passion that he had to do it. And, the nature of the crime itself is so gruesome. It implies a passion type of killing. Not that it can't be a plan to do it that way, but just, because of the likelihood, like you're saying, of how much could go wrong. The odds that there's nobody else in the house, the odds that nobody else wakes up, that nobody else, 2 people in the house that were there that did not get killed. The odds that they wouldn't have heard and perhaps called 911, these do not speak to an organized type of crime. And yet at the same time, we're to believe, well, but he took the murder weapon away and he took all these steps to conceal the DNA transfer and hid the digital footprint and turned off his phone, put his phone in airplane mode or whatever so that he wouldn't be tracked at the scene. And it just doesn't make sense. It's incoherent. The whole thing is quite incoherent to me. It's not a good theme. So for me, I'm with you. I'm just very skeptical of this theory, and this is one of the reasons why. It just doesn't make intuitive sense as to how it happened. Duncan, Idaho, it was his birthday 3 weeks ago. Come on. I mean, who isn't thinking to themselves, what do I need for my birthday that I had 3 weeks ago? Like, you're literally, you know, it's not quite 5% into, you know, towards your next birthday, 5% of another year, but it's getting close. Like 3 weeks ago, I don't know. I've had a lot of birthdays at this point. 3 weeks ago, yeah, those birthdays are pretty far in the rearview mirror. Not thinking about that anymore. It was such a silly excuse. Terrible justification. Gordon G, did you see Judge Bev snap at KR at the end of the jury instruction hearing? What was that about? She smiled or laughed about something. Would have liked to have seen Karen, but we didn't have that view of her. That's what it looked like to me. Like she just, you know, did something incredulous. She can't believe it. Maybe she's shaking her head laughing. Because that's what you do sometimes when you're disgusted and you're overwhelmed and you're incredulous and you just can't believe it. And yes, Judge Bev did not like that. She didn't like it at all. Is it inappropriate? Yes. Yes, it is. It's not nearly as bad with the jury not being in the room, you know, but it is, yes, it's disrespectful to the court. Does that justify that type of snapping out? Is something funny? Is this funny to you, Ms. Reed? I don't even remember what her exact words were, but something along those lines. We're done. We're done. Yeah, I don't know that it does. I really don't. I really don't know that it does. I mean, I guarantee you, far from the worst behavior she's had from criminal defendants toward her in that courtroom. I guarantee you she has had some talking back. She's had some sneering. She's had some cursing. You spend enough time on the bench going through those files, file after file after file, felon after felon after felon. Yeah. Far from the worst type of reaction like that. But a judge who is judicious and not emotional and reactive, you might address it, but you would address it something along the lines of, Mr. Jackson, please advise your client that her facial reactions, her expressions are inappropriate, and she should try to maintain her decorum in this courtroom. Something like that. All it takes. Not this snappy, something funny. Z, Turtle Boy confirmed on June 25th stream that not only did Bryan Albert not come out to help Officer John O'Keefe, also didn't attend his funeral, but made sure to attend trial. I had heard that before, that none of these people, they made this whole big thing about going to the NYPD officers, the fallen officer's funeral, right? The skin suit. Remember the skin suit they wore of that officer? Just absolutely cloaked themselves in that. You can't criticize me without criticizing a falling officer, because I'm with him. That's us. Can't criticize us without criticizing the O'Keefe family, because here we are sitting with them on their side of the audience. They're with us. Yeah, I had heard that before. But they didn't bother to go to John's funeral, and yep, here they are at the closing. I wonder if the jury noticed when they came back that they weren't there anymore. They were there for the closing and that was it. This is the time, I mean, you all know, we've been talking about it all day. Pins and needles, limbo. We're in the limbo state. This is the hardest time for the family. It's the hardest time for Karen. This wait. This is the time when you would expect. That's when you're giving them the support. Where are they now? Carazola X, how would you feel if after the trial and he's acquitted, BK releases a book titled "I Totally Did It and You Guys Are All Suckers"? If he was acquitted, then I don't think anybody is a sucker, mainly just because the deck is so stacked against him. It really is. Just in terms of the expectation and the faith that the law enforcement has solved this crime, there's no way they would have invested all of this in the wrong guy. They sincerely believe it's him, so it must be him. All of this is stacked so heavily against him. And so if he gets a not guilty, it's going to be because the evidence is pretty overwhelming. So if that's the case, can't really think we're all suckers. I can't really think we're all suckers. If he pulled off the perfect crime and both managed to hide and not hide it, not hide it enough to get caught, but to not get caught, but hide it enough to be able to get away with it after getting caught, then he's a criminal super genius. And that wouldn't make us suckers. So it just goes to whether the prosecution is able to prove it or not. It would be unfortunate if that were to happen. Might honestly frankly be better, at least for the families, and in terms of having closure and finality, might be better than if he gets acquitted and that's it. Maybe would be better than if he's just acquitted and that's it. Nobody else to look at. No other suspects. No closure in that situation. CG, if hung jury, can prosecution change their theory on retrial? I am worried that they learned facts that they will try to mold together better for next time. Yes, they can. Yes, they can, because the prosecutor's arguments are not evidence. So arguments the prosecution made at the first trial, they can't be raised in a second trial. It's not evidence. He's not being impeached. The issue is that it would potentially require witnesses to change their theories, their understandings, their, reports, what they focused on, what they don't focus on, and things like that. And so all of those things then can be subject to challenge by the defense. Hey, but you testified in an earlier proceeding about this, and at that point you didn't raise any of this. When you formulated your opinion about what happened last time, you said this, and now you're saying something completely different. So that's the challenge that they have if they try to go too far afield from the ground that they already laid down during this first trial. James Brown, not sure retired police officer on jury. I'm not sure what the configuration of the jury is, other than I know we have an equal number of men and women, which is that was kind of a long shot given how it started with the posture of the alternates and who's subsequently been excused and all of that. So equally male and female, and it's a male who is the foreperson. But other than that, I don't know. I'm not sure if it's been reported or if that was kind of kept, hush, 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 as far as what the backgrounds are. AKA Trad's Photos, American Standard Dog Training on YouTube, did a great video yesterday on J.O.'s arm, also references Dr. Russell's testimony. I was watching that this morning before we went live, so I'm about halfway through that. It is good. This is the same guy. He was on Melanie Little's show not too long ago. And did it, similar, a great presentation there. What I love about what he's done here is they have these like flesh-like molds that, these like arm molds that they use for the training, because he's pointed out there, it can be a problem if you're training like a police dog and it's using all of these equipment and under these controlled environments and stuff like that, that once the dog is then out in the world, the environment, it doesn't look like that. It's not being presented with the same circumstances. This is not a person wearing a bite vest and that big pad thing on their arm and running away and all of these similar circumstances. No, it's somebody who's like hiding in the bushes. They're bare. the dog isn't necessarily going to be able to put two and two together that this is the same context as that training context. So they have these arms, these like flesh-like molded arm things that this former police officer who was shot in the line of duty because of a situation like that. He created this to help with that training, help transition the dog from basically learning how to do it in that pure practice setting to making it more lifelike, making it more like it would be out in the field. But the cool thing about it is it really does show how those injuries work, how it leaves those marks, why it's, some of them are punctures, a lot of good information about the way dogs are trained to bite versus untrained bites. And yes, the comparisons with Dr. Russell's testimony, what she ultimately said, and how much in common there was with what he had said to Melanie Little, before the case went to trial. A lot of overlap there. So it was a very good one. I'm looking forward to finishing it. And yeah, that was a good recommendation that folks sent my way. Brian Bryson, am I missing something? Doesn't the snow give a timeline? Tail pieces found near ground, and he was on top of 3 foot of snow. I mean, to me, the fact that he was found on top of all of that snow, yeah, we have photos of it. We have descriptions of it. We have a whole understanding of why they needed to bring the leaf blower out in the first place, because the explanation was the blood had dripped down. So they had to remove the snow to get down to where the blood was to be able to get a sample of it. But that's in conflict with Kerry Roberts saying, no, he was on bare grass when we lifted him up. His back was on bare grass. He was covered with snow on top. So those are the conflicts that the jury has to resolve, the conflicts in the testimony. For me personally, I'm going to go with the photo. But if they've got a coffin doffer on the jury, and they don't want to believe that, I'm sure they can come up with reasons why there would be snow in that photo, even though he was on bare ground at the time. Well, it was just all the traffic, and they were moving him around, and it would have got compacted, and so on and so forth. So to me, that part of the explanation is pretty straightforward, but there are conflicts in the testimony. The jury has to sort it out. As far as where the taillight pieces were found, I just have a challenge with being able to put much weight on the taillight pieces when this whole area has been so disturbed, mainly by the plowing. The CERT search was the first one there that shows up, and they're digging in the street. They're finding stuff in the street. So they're in the area where the plow has been through. The plow has thrown up a snowbank. There's been so much disturbance here. I think that's going to interfere with the crime scene. The rest of it, pieces on the bare grass. I mean, this is coming from Buchanan and Proctor. I think the main problem there is just the people who were there when there was almost no snow, and they were leaf blowing away the snow that there was to look for it, didn't see any of it. But then weeks later, it's revealing itself. If somebody wants to believe it was already there, they can. There's enough in the record to support that. James Brown, Bev had just giggled at Yannetti. KR just joined in. Yeah, she had kind of giggled at him. I think everybody was getting frustrated with each other, and for some reason, it was just very triggering for Karen to be involved in that as well. I don't know what's up with the judge and her attitude, who her problem is with or why. I really don't. I did find it interesting that she was looking to Mr. Yannetti to be her ally on that issue of the jury form. And there he was not. Just makes me wonder because, I mean, Mr. Yannetti didn't and hasn't had an easy time from Judge Bev either throughout this process. But now, out of everybody over there, he's the one she goes to. Makes me wonder who exactly her problem is with. I'm not sure if it's the attorneys at all. I do kind of wonder. If it's Miss Reed. Just gotta kind of wonder if her problem is Ms. Reed. All right, guys, we're gonna go ahead and get back to the verdict watch. It's 2:49 over there on the East Coast, so not a whole lot of the day left. Maybe we'll hear soon. I am ready, just so you know, I am monitoring. I am ready to go live as soon as we get word that there is a verdict. So we will get back to it. Never fear. Oh, and hey, check it out. We already have our scheduling order from this hearing. Let me go ahead and see if I can pull that up. Just to bring things full circle back to Mr. Kohberger. All right, here it is. Don't know if you can see everything real clearly from here, but jury trial shall commence at 8:30 on June 2nd and will run until August 29th. So that is going to be a long, busy summer. Long, busy summer in Latah County on an 8:30 a.m. to 3:30 p.m. schedule. They have excluded the Juneteenth holiday and the July 4th holiday. And it says, okay, so it contemplates the defense's motion to change venue is currently set to be heard on August 29th. If that motion is granted, the court anticipates that the trial dates will not change, although the location of the trial would. So they are planning on this being a fixed time, regardless of what happens with the change of venue. A final pre-trial conference will be held on April 3rd, 2025 at 10 o'clock. Any motions challenging the death penalty shall be filed on or before September 5th, then responses throughout October, and then hearing on November 7th. Motions to suppress and any other 12B motions to dismiss, shall be filed no later than November 14, 2024. Responses throughout December and January, and then a hearing on the motions on February 6th, continuing into February 7th if needed. Motions in limine filed by February 13th, 2025. So almost 4 months ahead of the trial. They're building in a big window here to have the responses throughout March, and then a hearing on March 27th, continuing into March 28th if needed. So more than a month ahead of trial, they would have the rulings on in limine. So the state's discovery deadline is September 6th. The defense's discovery deadline is January 9th. That is normal to have those kinds of staggered deadlines so that because the defense is going to conduct additional investigation, once they have all of the state's discovery in. So it just builds in that buffer for them to have the time to be able to respond. I'm going to see if I can... Okay, yes, we can get it a little bit bigger here. Disclosure of trial experts from the state from the state by December 4th, and then the defense's experts by January 9th, rebuttal experts from either side by January 30th. Proposed jury questionnaires by February 7th. A closed, sealed hearing on the jury questionnaires held on April 2nd, 2025. I don't know why this one would be sealed either. Certainly individual responses to jury questionnaires are and should be sealed. But what's on the jury questionnaire that goes out? Don't know that I understand that. He's got some rule citations here, so maybe I'll go and look at that at a later point and see if it's something specific to Idaho, but my knee-jerk reaction to that is weird. I don't know why we would need to seal that. Proposed jury instructions by March 14th. Lay trial witnesses filed by March 14th. Exhibit lists by March 14th. So he wants everything ready to go for trial well in advance of trial, including the trial brief on or before March 14th. Month and a half. He wants everybody to be ready well ahead of time. Then sentencing disclosures from the state by January 9th, from the defense by March 3rd, and then rebuttal by March 31st. With this catch-all language, court reserves the right to hear anything filed after a deadline has passed if good cause is shown, including but not limited to motions that arise after a disclosure made by the opposing party. So there we have it. Nothing super imminent here, but the motion to change venue. So that is the next thing, as far as we know right now, that is going to be on the docket, August 29th of 2024. Oh, I will definitely be paying attention to that. So he didn't set a briefing schedule on that motion, which is a little bit surprising, but I would expect at least by July we should be hearing something. It's been underway for quite some time, and the technical deadline rules don't provide for really a massive amount of notice to the state, but just under the circumstances, you would anticipate, yes, of course, they're going to want to have time to respond, potentially have their own people review the basis and so forth. So they would likely move to continue it if they don't get enough notice anyway. But soon, I would expect then soon, probably no later than maybe the end of July, that we get that motion and hopefully get to see the basis for that. So there we have it. We have a trial date, guys. Been waiting for that for a long time. June 2nd. June 2nd. Not quite a year from now. Seems very far down the road, but I guarantee you to this defense team, seems like maybe it's just right around the corner. So much to do. So much to do, and they will be sprinting all the way to the finish line. So guys, I don't know what the process, I just saw in the chat about if cameras will be allowed. I don't know. The judge has been very good about allowing cameras in. I mean, not allowing cameras in, but basically letting us live stream from the court's own camera system. Any hearing that he is not sealing off to the public. No indication here that it would be a sealed hearing on the motion to change venue, and not really a clear understanding of why that would be. I don't think there is a good basis for that. If you go back into my Substack, back when they were talking about sealing some of the hearings in this case, I did a breakdown of what the law is on that. It's really very nominal, very minimal circumstances where they should be able to close the courthouse doors. If they are not closing the courthouse doors, then they have been very good about doing that live stream through the court's camera system. So hopefully, that will continue to be the case. So let me take a look at these new comments that have come in. Russell 2.0, because of the gag order, is there evidence against Bryan that no one knows about or has been presented yet that the prosecution can sit on and only introduce at trial? We have to assume there is. I mean, what we know, what's public, is just a tiny drop in the bucket of what they have done throughout their investigation. Just at the very minimum, for example, the roommates. We know very little about what the roommates may have to say about this entire situation. We know a little bit from DM, from the probable cause affidavit, her description of what she saw that night, and then, described being in the frozen shock state But as far as the other roommate, we really know nothing. We know nothing about the circumstances of the 911 call. We have to assume they've done all kinds of investigation into Bryan's background, into, what was going on at WSU, his teaching position, all this other stuff that there's been kind of a fair amount of misinformation apparently out there about. But we have to assume that the prosecution has a lot of that stuff. So I don't know how strong any new information they have is, but they've had his phones, they've had his computers, they've had his car. They've had all kinds of opportunity to develop new evidence. It doesn't seem like that's been fruitful based on the statements that the defense has made in their pleadings. But the prosecution has been pretty tight-lipped. They haven't responded to those. They haven't, taken the opportunity to put in their written filings, oh, there's this other new evidence. They're just kind of allowing these defense statements to go out there and be unchallenged. Doesn't mean they don't have the evidence. They could have, potentially just decided, look, the jury panel is already, it's just already an issue. The publicity that's been out in the case, we don't necessarily need to add to it. And frankly, the more that is out there that leads people to think that maybe he is innocent, the more that's going to make it a fairer process at the end of the day. Because that is the starting point we're supposed to have. We're supposed to start from the standpoint that Bryan Kohberger is innocent. And so if defense statements can help shift the pendulum back towards that direction, then maybe if the state would be inclined to quibble them with them, maybe even if they would, it would be better to just remain silent. I can see all kinds of reasons for that. So yes, we have to assume there is a ton of evidence that we don't know anything about. We just don't know. We don't know how strong it is or how weak it is. Dennis Jensen. In Denmark, we just had our first murder conviction based on police agent Frank put into same facility where the suspect was serving time for attempted murder. Hundreds of hours of taped conversation. So an informant, a jailhouse informant. If they taped it, that's, way better than the quality of most of what we're used to getting in informant types of cases. Most of the time it tends to be extremely, extremely poor quality, not substantiated. Lots of reasons to question the motives of the person who is making that comment. In the United States, if the police are using an agent, using somebody as an arm of law enforcement to go in and talk to somebody in jail, it's going to be a problem. They're going to be treated like a de facto police officer, and so it creates problems both in terms of, did you Mirandize the person before you had the conversations? Of course not, because that would blow their cover as an undercover. But also, if this person has the right to counsel, you talking to them after they have had an attorney appointed in a case is a major problem. You have to go through their attorney. It's a violation of their rights if you don't do that. But if somebody is just sitting in trial on, or sitting in jail on perhaps something unrelated, and decides, to chit-chat, as sometimes happens in the pod. People do like to chit-chat. Then, yeah, potentially that could be a problem here as well. So, interesting situation. It's probably a big cultural difference as far as how crimes get investigated and prosecuted. Between the U.S. and Denmark, we rely so heavily on those jailhouse informants, even when the quality seems pretty bad. James Casatelli, why would DM be frozen in fear? All she saw was a guy. She didn't know a murder had occurred at that point. Doesn't make sense. Yeah. I mean, I understand. I do. I understand this perspective. I don't know, because of course the probable cause affidavit is just a kind of parcel recitation of what was said, and it's a summary of what was said. It's not, I don't think, meant to be verbatim, like it's not quoted. It's not indicating like it's taken from a recorded statement or something like that. So I don't know how much to attribute to this is DM's explanation versus this is the police officer's explanation for what DM said. I can certainly see how somebody, you know, waking up the next morning and discovering a crime scene could be could be in a frozen shock state for quite a period of time. I could also see a situation potentially where she saw something that would shock her that night, but you don't remember it. Not that uncommon with trauma to just have no memory of basically the worst stuff. So maybe doesn't understand why she went into a frozen state of fear, because she doesn't remember. I can see that. I want to give as much grace to the roommates as I possibly can, until we get to trial and we get to hear from them. I understand there's a lot of people who were kind of suspicious of them, and I understand, yes, they survived, and that seems weird. People would want to know why. But I just, assuming, as I'm going to assume at this point, absent any evidence that like they're involved or they know more than they have to say, that this was unbelievably traumatic for these girls. I would absolutely expect that. So I want to give them as much grace as possible until we get to a point where perhaps we have just better information. Tim Harris, 2.5 years to prep seems like too much. I'm thinking a place like Chicago with upwards of 2 murders a day. I don't think Illinois has the death penalty. I mean, I can't overstate how big a part of this, a big a part of the time that it takes is the fact that this is a death penalty case. It's just like the mitigation alone, like she was talking about today. It's a huge part of what they have to do. That is, I mean, it's not that you don't ever do, you should be presenting mitigation evidence at pretty much any sentencing, but just because of what is at stake, because of the standards that are out there as far as what you need to be looking into, who you need to be working with, experts you need to be consulting with, that kind of thing, that are specific to death penalty cases. That takes a massive amount of time that you're not going to get in other cases. Just in general, the capital case, the expectations are much higher because so much is at stake. You really are under pressure to, turn over every stone in a way that, yes, ideally you would do that in every single criminal case. But there are practical limits. There are practical limits on that. So those limits tend to drive the timeline a little bit more in lesser and lower cases. That said, Chicago, pretty sure their trial schedule is pretty backed up. Pretty sure it's pretty backed up. I don't know about 2.5 years waiting to trial, but wouldn't surprise me if murder cases are over a year. Wouldn't surprise me at all. I don't know how many of the murders in Chicago are prosecuted. I'm not sure what their clearance rate is. I'm not sure that they have a very good clearance rate, a rate of solving murders and actually transitioning them into the courtroom. Chicago's not my turf, but I could definitely see, there's obviously, if they prosecuted everything that happened there, no, 2.5 years, You would just it would backlog. It would create such a massive backlog if every single case took that long. You know, it would be like decades later. You'd still be trying things. All right, guys, we got the order. We went through the order. Now, now we get to go back to our Karen Reed verdict watch. 3:08 p.m. over there on the East Coast. I will reiterate, I am watching, I am waiting. As soon as we get notification, I will be going live. We will be here for the verdict, whatever it is, good or bad. We'll be ready for it, and we'll talk about it, and we'll recap, we'll commiserate, we'll just see where we're at. It's going to be a process. There's going to be some after stuff as well, kind of regardless what happens. I would expect there's likely to be statements from the prosecutor, potentially from the family, potentially from Karen and her family and her team. So we'll be trying to keep an eye out for all of that stuff. And yeah, however it comes down, we'll be ready for it. So guys, thank you so much again for joining us here today. Wasn't the most exciting hearing ever, but hey, now we know at least a little bit of what to expect. We can, if nothing else, have October 29th on our calendars for that motion to change venue. Doesn't mean nothing else will happen in the meantime. If it does, I will let you know, and I will plan to cover it one way or another. So thanks again for joining me. Thank you for all of your wonderful questions. It's nice to have the crew back. We got the band back together. Is it not that I was complaining about, kind of getting to sleep in a little bit. I slept all the way into 5:45 today. I think this is just my life now. This is my new normal. But we'll be ready, guys. So thank you again for joining me. I look forward to seeing you again soon. And once we get this verdict from Karen Reed, then we'll start looking forward to the future and what else it holds. So look forward to seeing you then, guys. Fingers crossed it'll be soon. But when it happens, we'll be here. And I hope to see you then.